a quiet archive record. Tonight, we're stepping into a slow unfolding. Settle in, let the outside world dissolve, and gently descend into tonight's world. In this episode, we move carefully through the unanswered questions that continue to surround Jeffrey Epstein. How a little-known figure gained extraordinary access, how warnings accumulated and then seemed to disperse, how legal outcomes diverged from public expectations, and how the final weeks inside federal custody produced lasting doubt. We will stay with what can be dated, sourced, and placed on a timeline, and we will mark the spaces where the record turns thin. This is not a courtroom, and it is not a verdict. It is a calm walk through documents, reporting, and persistent uncertainties, asking what would be required to settle them with clarity. This is Epstein, Unanswered Questions, Chapter 1. The Man Who Appeared. Begin tonight with a simple image, a name on a flight manifest, a line in a contact book, a photograph at a crowded event, all smiles and soft lighting. For many people, Jeffrey Epstein arrived into public awareness not as a person, but as a silhouette in the background of other people's stories. He seemed to appear in places where power gathered, and yet, for years, there was no widely understood explanation for why he was there. So the first unanswered question is also the quietest. Who, exactly, was he in practical terms, and how did he come to be positioned the way he was? The public record sketches an outline. He was born in 1953. He attended college, though accounts vary on details and completion. He worked as a teacher at a private school in New York in the 1970s. Later, he moved into finance. Those broad steps are simple enough. What remains harder to pin down is the mechanism of ascent. In stories of wealth and influence, there is usually a legible ladder, a company founded, a partnership announced, a series of transactions that leave a paper trail you can follow in annual reports and court filings. With Epstein, the ladder often looks like mist, and in mist, certainty is a feeling, not a fact. We may never know every rung of that ladder. We may never know which introductions were innocent, which were strategic, and which were warnings disguised as charm. We may never know, with perfect completeness, how much of his self-presentation was accurate and how much was performance. But we can still do something quieter and more reliable. We can name what is documented, what is plausible, and what remains unproven. It is not that there is no reporting, or no claims, or no plausible explanations. There are many. It is that the explanations compete, and the documentation is uneven. Some accounts emphasize a talent for cultivating relationships. Others describe a small number of high-value clients. Others point to associations with major figures in business and philanthropy. And over it all hovers a question that is never far away. How much of what he claimed about his role, his work, and his wealth can be independently verified? If you are listening tonight for a single, clean answer, you will not find it here. But you can find a way to approach the question. You can treat it like an archive problem. When someone rises quickly, the archive usually leaves clues. There are employment records. There are corporate filings. There are tax documents. There are property records. There are contracts. There are the small, ordinary traces of doing business. And so one way to frame this first chapter is not as a story about charisma, but as a story about paperwork. What paperwork exists? What is missing? What is sealed? What is rumored? What can be cross-checked? A recurring reference in discussions of Epstein is his time around Bear Stearns in the 1980s, and later his claim to operate as a money manager. Money management can be opaque by design. Private wealth offices do not always advertise. Client lists are protected. Agreements can be confidential. That privacy is not, by itself, suspicious. It is normal in certain circles. But privacy becomes troubling when the scale of influence appears to exceed what the known professional footprint would predict. So listeners return to a set of practical questions. How many clients were there? Who were they? What were the fees? What were the returns? Where were the statements? Where were the audited reports? What regulated entities were involved? It is possible that much of this is ordinary and simply private. It is also possible that some of it was exaggerated. It is possible that the story varies by time period. Private wealth can be real in one decade and inflated in another. When you encounter uncertainty, you can slow down and ask what would resolve it. If the claim is that he managed large sums for named clients, then the strongest evidence would be contemporaneous. Signed agreements, correspondence, statements, tax records, and testimony that can be independently corroborated. If the claim is that he used his access to arrange introductions and deals, then the archive might live in calendars, letters, invitation lists, and the memories of the people who were there. If the claim is that he operated in realms adjacent to intelligence or law enforcement, then the evidence would need to be more than rumor. It would need to be documents, confirmations, and a clear chain of accountability. Those rumors exist in public conversation, but rumors are not evidence. They drift because they fill a void. They persist because the ladder looks like mist. Another early question concerns a major patron, often discussed in reporting. The relationship with Leslie Wexner, a prominent business figure. In any story of patronage, you can ask, what assets were transferred? Under what legal instruments? What were the roles? What authority was granted? What oversight existed? How did that oversight change over time? Property records and corporate documents can clarify portions of that relationship, though interpretation can still vary. And then there is the question of philanthropy. Epstein was associated with scientific and academic circles, hosting dinners, making donations, appearing at events where researchers and wealthy donors mingle. In those settings, influence can be built quietly. You do not need a public company. You do not need a bank tower with your name on it. You need a room, a guest list, and a sense that you can open doors. Unanswered questions about the early years are not just gossip. They matter because they set the context for everything that follows. If access was built through legitimate wealth and social skill, that is one story. If access was built through manipulation, misrepresentation, or other hidden leverage, that is another. And if access was built through a mixture of ordinary networking and something darker, then the truth could feel slippery. Parts of it would look normal, and parts would not. To understand that slipperiness, it helps to look at the way wealth can be presented without being explained. Some fortunes are loud. They arrive with quarterly reports, interviews, and a visible enterprise. Others are quiet. They exist inside private partnerships, trusts, and service agreements. In the quiet form, the question is not only how much, it is from where and through what route. Consider the basics that an investigator would map: a timeline of property purchases, dates, purchase prices, ownership entities, liens, renovations. A timeline of aircraft use, tail numbers, leasing arrangements, maintenance logs, hangar contracts. A timeline of staffing, household managers, drivers, assistants, security, pilots. A timeline of bank relationships, which institutions, which accounts, which signatories. Each timeline is a different way of testing a life story. If a person claims to be a private advisor to billionaires, you would expect to see patterns consistent with that work. Travel to financial centers, meetings, communications, and the kind of professional infrastructure that handles large sums. If a person is instead living mainly as a host and connector, you might see a different pattern. Dinners, guest lists, repeated visits from the same social circle, donations that open doors, and a staff that is optimized for hospitality rather than finance. And if a person is living as an operator of a hidden system of exploitation, you might see still other patterns: secrecy, compartmentalization, payments that look like hush money or recruitment incentives, and routines designed to keep certain activities out of view. The archive around Epstein suggests that his world had more than one layer. There was a visible layer where he presented himself as a benefactor of science and an intimate of influential people. There was an operational layer where assistants scheduled, drivers transported, and properties were maintained with quiet efficiency. And there was, according to many allegations and later legal findings involving associates, a predatory layer that drew young women into harmful situations. Those layers can overlap. In fact, overlap is often the point. A dinner party can create an alibi of normality. A charitable donation can create gratitude. A prestigious introduction can create silence. So another unanswered question in the early years is how many people saw only the surface, and how many had glimpses of the deeper pattern. In practical terms, glimpses might look like a staff member noticing unusually young visitors, a driver repeatedly transporting teenagers, a house manager receiving instructions that do not fit the stated lifestyle, a guest hearing rumors and choosing not to ask. In many real cases, people do not see everything. They see a fragment and they explain it away. That is why the early archive matters. It is not just about money or status. It is about the social physics of disbelief. If the surrounding world believes someone is important, then warning signs can be reframed as misunderstandings. If the surrounding world believes someone is eccentric, then boundary violations can be reframed as quirks. And that is what makes the question of origin so consequential, because the story of how someone became powerful is also the story of why others assumed they should be trusted. Tonight, as you settle deeper, notice the rhythm. A question forms, a possible explanation appears. Then the archive asks for proof. When proof is not available, the question remains. And in this case, the question remains not because no one has ever looked, but because the record has gaps, and because many of the people involved have strong incentives to stay silent or to speak carefully. Before we move on, let us place one more anchor in the timeline. By the early 2000s, Epstein owned or controlled multiple properties associated with him in public reporting. A townhouse in Manhattan, a residence in Palm Beach, a ranch in New Mexico, and a private island in the US Virgin Islands. Real estate is another kind of archive. It leaves deeds, it leaves mortgage records, it leaves corporate shells, it leaves renovation permits, it leaves staff payroll, it leaves travel patterns. If you want to understand a person's life, you can sometimes learn more from the kitchen than from the boardroom. Who cleaned? Who drove? Who booked flights? Who scheduled appointments? In later legal proceedings and reporting, staff and associates become key witnesses because they saw the daily routines. And routine, repeated day after day, can reveal what rhetoric hides. So chapter 1 ends with an open doorway. We have an outline of ascent. We have a ladder that does not fully show its rungs. And we have a set of locations where a private life intersected with many public lives. The unanswered questions are already present. How did the money work? How did the access work? Who vouched for him? Who benefited? Who noticed? Who looked away? And what would it take in records and testimony to turn that mist into something clear enough to hold? Chapter 2. The first warnings. Now let the pace slow further. In many cases of long-running harm, the most haunting part is not the final collapse, but the early warnings that did not stop it. And with early warnings, there is a particular kind of uncertainty. We may never know every person who tried to speak. We may never know every report that was made and then filed away. We may never know how many small decisions, each one easy to rationalize, added up to an outcome that later looked impossible to defend. In the Epstein story, public attention often centers on the 2006 to 2008 legal process in Florida and on the plea deal that followed. But before a case becomes a headline, it is usually a series of conversations. A parent speaking to police, a young person telling a friend, a complaint written on a form, a detective trying to connect scattered accounts. The unanswered questions here are not only about decisions made at the top, but also about how the system handled the first signals. What did local law enforcement learn and when? What allegations were recorded? How were witnesses interviewed? What evidence was collected? What was forwarded to prosecutors? There is a timeline that can be traced in public reporting. In 2005, the Palm Beach Police Department began investigating allegations involving underage girls and sexual misconduct. Over time, more allegations surfaced. Investigations are often built through small, concrete steps. You identify victims. You gather statements. You corroborate where you can. You look for patterns. You seek physical evidence when possible. You map phone records. You interview staff. You examine financial transactions. A key unanswered question is the degree to which this process unfolded fully, and how much of what was gathered was later diluted by negotiation, jurisdictional issues, or strategic choices. When a case involves wealth and influence, the gravitational pull is different. Defense teams are large. Experts are hired. Public relations is considered. Political relationships can exist in the background. None of that proves a corrupt outcome. It simply changes the environment in which decisions are made. And in that environment, small choices can reshape the story. Which charges to pursue, whether to pursue state or federal prosecution, whether to seek a plea, what conditions to require, how to communicate with victims. The 2007 non-prosecution agreement, often discussed and criticized, remains a central node of unanswered questions. Why were the terms structured as they were? Who participated in the negotiations? Who approved them? What leverage was used? What alternatives were considered? In later years, reporting and litigation raised issues about victim notification and whether legal requirements were properly followed. Here, the archive grows more complex. There are court filings, there are emails, there are public statements, there are recollections that differ. In calm documentary fashion, we can treat these as layers. Layer 1, the allegations and the investigative work. Layer 2, the prosecutorial decision-making. Layer 3, the outcome and its practical effect. A practical effect is not an abstraction. It is the difference between incarceration and freedom, between deterrence and continuation, between exposure and secrecy. When a plea deal is reached, it can sometimes stop ongoing harm. It can also, if structured poorly, allow it to continue. One of the unanswered questions is what was known about the broader pattern at the time of the Florida case. Was the misconduct understood as limited or as systemic? Were associates considered as possible co-participants? Were recruitment dynamics investigated? Were other jurisdictions informed in a way that triggered parallel investigations? Because Epstein had connections and properties beyond Florida, a case that remains local can miss a larger network. And yet, building a multi-jurisdictional case is difficult. Agencies have boundaries. Evidence has to be shared. Resources have to be justified. So another question becomes, did the system treat the case as a narrow Florida matter because that was all it could see, or because that was all it chose to see? We can imagine two broad explanations. One explanation is institutional limitation. Investigators and prosecutors faced legal constraints, uncertain witness cooperation, and the usual friction between agencies. Another explanation is undue influence, that the defense successfully negotiated an unusually favorable deal due to power, connections, or pressure. There may also be a third explanation that is less dramatic but common, a mix of ambition, risk aversion, and an imperfect assessment of what a jury would do. In the real world, prosecutors sometimes accept deals they do not love because trials are uncertain. But when the allegations involve repeated exploitation of minors, and when the accused is wealthy, the public expects more than ordinary caution. That expectation is part of why this case still aches. It can help here to imagine the case file as it might have sat on a desk. Inside are witness statements, some consistent, some messy. Inside are notes from interviews, where a young person might contradict herself on a minor detail because fear and shame distort memory. Inside are leads that go nowhere, and leads that branch into other towns. Inside are decisions about which witnesses are strong enough for trial and which might be vulnerable to attack. A plea agreement, when viewed from the outside, can look like a single moment of surrender. From the inside, it can be the end of a long calculation. But the unanswered questions here are about the nature of the calculation. What risks did prosecutors believe they faced? What did they think a jury would do? What did they think the legal exposure truly was? Sometimes the difference between a sweeping case and a narrow case is not willpower, but statute. Different charges have different elements. Different charges have different limitations, periods. Different charges require different kinds of proof. A case that rests on many young witnesses can be strong in pattern and still fragile in the courtroom moment. That said, pattern is also evidence. When many independent accounts align in structure, it can be powerful. So the question becomes, did the system fully use the power of pattern, or did it fracture the pattern into isolated incidents and then settle for a minimal outcome? Another unresolved area is the degree to which potential co-participants were examined. If recruitment occurred, who recruited? If transportation occurred, who arranged it? If payments occurred, who tracked them? In many investigations, the first case focuses narrowly on the most visible person. Only later, if at all, does it widen. In the Florida matter, the outcome did not obviously widen the circle. That leaves a lingering question of strategy. Was the goal to secure a quick conviction? Was the goal to minimize harm to victims by avoiding a trial? Was the goal to preserve institutional reputations? To disentangle these, you would want transparency about deliberations, not only what was decided, but why. Which options were debated? Which options were dismissed? Which legal memos guided the decision? You would also want a victim-centered archive. What were victims told? When were they told? What opportunities were they given to be heard? In later legal disputes, the process of notification became a central issue. That matters because it reflects whether victims were treated as participants in justice or as inconveniences to be managed. A system can be technically lawful and still emotionally brutal. And when a system feels brutal, it creates the kind of distrust that does not fade. There is also the question of how much information was available publicly at the time. When the public does not see the full investigative file, it cannot judge the strength of the evidence or the reasoning behind compromises. Secrecy can be necessary to protect victims. Secrecy can also protect institutions. So a careful listener asks, what would be needed now to reduce the unanswered questions? A fuller release of contemporaneous investigative documents, appropriately redacted to protect victims. A detailed accounting of decision-making, including communications between prosecutors and defense. Clear timelines of who knew what, when. Some of this has emerged in piecemeal form through lawsuits and reporting, but piecemeal releases often create new uncertainties because they show fragments without the full frame. And then there is the human question that is both simple and heavy. How many people tried to speak up early and were not heard? In stories like this, warnings can be minimized in subtle ways. A report is treated as rumor. A victim is treated as unreliable. A pattern is treated as coincidence. A powerful person is treated as untouchable. None of those choices has to be explicit. They can happen through tone, through delay, through bureaucratic drift. If you want to know whether that happened, you look for the small signs in the archive. Was an interview written up promptly? Were leads pursued? Were search warrants sought? Were devices seized? Were travel records requested? Were potential witnesses followed up with? In some cases, years later, investigators say they tried. In other cases, victims say they were not taken seriously. The truth may contain both. As you listen, let the questions settle like snow, not to numb you, but to clarify. Because clarity matters. It is possible to be calm and still insist on precision. By the end of chapter 2, we are standing at a hinge. A major legal resolution occurred. Epstein served a sentence that was widely viewed as lenient, and then he returned, at least for a time, to a life of wealth and movement. Which leads to the next unanswered question. What changed after the first warnings, and what did not? Chapter 3. The Web of Names. Tonight, we enter the part of the story that often becomes loud in public discourse, the list of names. But we will keep it quiet. Names in an archive are not conclusions. They are coordinates. They tell you where to look not what to believe. And even with coordinates, we may never know the full story behind every entry. We may never know why a number was saved. We may never know what was said in a room that kept no minutes. We may never know which relationships were deep and which were incidental. A name in a phone book can mean a real friendship. It can mean a single meeting. It can mean a number written down by an assistant. A name on a flight log can mean a passenger. It can also mean a typo, or a staff member, or someone who changed plans. And so the unanswered questions in this chapter require discipline. What can be established? What is suggestive but not definitive? What is unknown? Epstein's social world, as described in reporting and legal filings, seemed to bridge many domains: finance, politics, academia, entertainment, royalty, philanthropy. In ordinary life, domains remain separate. In high society, they mingle. That mingling itself is not unusual. What is unusual and disturbing is the claim that within this mingling, there was a pattern of exploitation, recruitment, and abuse. The question that persists is how that pattern interacted with the broader web of names. Who knew? Who suspected? Who heard rumors? Who ignored them? Who distanced themselves? Who may have enabled? The archive contains several types of material that people use to argue about these questions: flight logs, address books, calendars, photographs, witness statements, civil lawsuit allegations, criminal case filings, media reports. Each type of material has a different weight. A sworn statement is not the same as a rumor. A civil allegation is not the same as a criminal conviction. A photograph proves proximity, not behavior. A contact entry proves awareness, not complicity. If you are trying to understand the web, you would start with structure. Where were the properties? Who managed them? Who traveled between them? Who worked as drivers, assistants, security? How were young women brought into the orbit? This is where the notion of recruitment becomes important. In multiple accounts, recruitment is described not as a single act, but as a system. One person brings another. Incentives are offered. Normal boundaries are eroded, and secrecy is maintained through a mix of manipulation and fear. If that system existed at scale, it would create traces, phone records, payments, text messages, transportation logs, security footage, keycard entries. One unanswered question is how much of this trace has been fully examined by law enforcement across all relevant years, and how much remains in private hands, destroyed or unrecovered. The digital era changes this. A person can delete a message, but service providers may retain metadata. A phone can be discarded, but backups can survive. A hard drive can be wiped, but forensic recovery can sometimes resurrect fragments. The strength of any future clarity would depend on whether devices and accounts were preserved early enough. Another unanswered question involves the boundary between rumor and reality regarding Epstein's leverage. Some accounts suggest he collected information about powerful people. Others suggest he hosted gatherings designed to create compromising situations. Still others suggest he simply enjoyed proximity to power and used the appearance of influence as a tool. The archive can be thin here. If compromising material existed, where is it? Who held it? Was it ever seized? Was it ever destroyed? If it did not exist in the dramatic form people imagine, why does the belief persist? Beliefs persist when patterns are confusing. A lenient plea deal, continued access to elites, a return to luxury. These things can feel, to an outside observer, like protection. Protection could be real. Protection could also be an illusion created by money, lawyers, and the normal reluctance of institutions to confront complexity. In this chapter, we can also acknowledge a delicate point. Many people who are named in connection with Epstein have denied wrongdoing. Some have said their association was limited or professional. Some have said they severed ties when concerns emerged. It is not our role tonight to declare guilt. It is our role to note the questions that a careful investigator would ask. When did the association begin? What was the nature of it? When did it end? What did the person know about allegations, and when? Did the person travel to properties linked to misconduct? Did the person communicate with known associates? Were there financial ties? These questions can often be answered, at least partially, through documents, travel records, emails, meeting logs, financial transfers, visitor logs. But many of those documents are private, and in some cases, legal fights over unsealing records have revealed only portions. This creates an ethical hazard in public conversation. People fill gaps with certainty. Tonight, we do the opposite. We pause over the raw materials that people argue about, and we ask how each one should be handled. Take a flight log. A flight log is a technical document created for operational reasons. Fuel planning, compliance, scheduling. It may include abbreviations, nicknames, misspellings, or last-minute changes. Sometimes it records who was expected to be on board, not who actually boarded. Sometimes it is completed after the fact. So the question is not merely, is the name there? It is, how reliable is this specific entry? To evaluate that, an investigator would cross-check the aircraft tail number and its maintenance history, the stated route against air traffic records, the date against other calendars, the name against passport records, if available, the name against security logs at departure and arrival. A contact list has its own logic. Contact lists can be copied from other lists. They can be built by assistants. They can contain aspirational entries, names written down because someone hopes to know that person. They can contain old numbers for people met once. So to assess a contact entry, you ask, was there actual communication? Are there emails, calls, meetings? Are there contemporaneous notes? Photographs, too, require a quiet mind. A photograph can prove that two people were in the same space, but many spaces are public. A gala photo can be meaningless. A private dinner photo can be more telling. Even then, the meaning depends on context. Were they seated together? Was it a one-time event? Were they part of a recurring circle? Civil suits add another layer. Civil complaints can contain serious allegations. They can also contain errors. They can be used to seek discovery, to pressure settlement, or to win damages. That does not mean they are false. It means they are a starting point, not an end point. So the most careful approach is to treat the web of names as a map of investigative priorities. A map says, follow this route. A map does not say the destination is already known. In a case that intersects with status and reputation, this matters. There is a temptation to make a name function like a verdict, but justice is not a list. Justice is a chain of proof. And when the chain of proof is incomplete, the ethical thing is to keep the difference visible. We fill gaps with calm, labeled uncertainty. One of the most persistent sets of unanswered questions involves Ghislaine Maxwell, Epstein's longtime associate, who was later convicted of crimes related to trafficking and recruitment. Her case provides some structure because it produced a trial record, but even a trial record can be narrow. Trials focus on specific charges, specific timeframes, specific victims. So listeners ask, does that record capture the full scope? Does it capture the full set of participants? Does it capture the full geography? The answer, in most large cases, is that it captures something, but not everything. And so, even after convictions, a web can remain. A web can have strands that were never tugged. If you want to tug them, you need resources and will. You need prosecutors willing to pursue additional cases. You need victims willing to testify. You need evidence that can survive cross-examination. You need statutes that allow charges within limitations periods. Some of these conditions may not hold. So another unanswered question becomes, what is possible now? This is a quiet kind of question, because it is about time. Memories fade, documents are lost, witnesses die, jurisdictions change. Time is not neutral. Time favors those who want the story to dissolve. And yet, time can also favor truth, because documents are sometimes unsealed later, and people sometimes speak when they once could not. In the background, there is also the question of international dimensions, travel across borders, contacts in multiple countries, properties that involve different legal systems. International investigations are hard. They require coordination. They require treaty processes. They require patience. In a world that prefers fast answers, patience can look like avoidance. But sometimes patience is simply the cost of doing it properly. As Chapter 3 closes, the web of names is still a web. Some strands are well documented. Some are suggested. Some are imagined. The unanswered questions are not solved by a list. They are solved by casework, by evidence, by timelines, by corroboration, and by a refusal to mistake proximity for proof. Now, we move toward the final year, when the story tightened and the archive became louder. Chapter 4. The Return of the Case. In 2019, Jeffrey Epstein was arrested on federal charges in New York. For many observers, it felt like a delayed thunderclap. And yet, even a thunderclap does not illuminate everything. We may never know all the internal conversations that led to renewed action. We may never know which tip mattered most, which memo changed a mind, which witness finally tipped a scale. Years had passed since the Florida plea deal. There had been investigative journalism, there had been whispers and warnings, and then, suddenly, the machinery of federal prosecution moved. An unanswered question begins right there. Why then? To ask that is to ask about timing in institutions. Sometimes timing is created by a new leader who looks again at an old file. Sometimes it is created by a journalist who documents what others had dismissed. Sometimes it is created by a witness who decides, after years, that silence is no longer possible. There is also the possibility of jurisdiction. A state case can stall. A federal case can reopen the door if there is evidence of crimes that cross state lines, involve trafficking statutes, or fit federal charges. But a federal case still requires something concrete. Investigators may seek phone records, they may seek travel manifests, they may seek testimony from staff, they may execute search warrants, they may examine financial transactions. Each step takes time, and in high-profile cases, each step can face legal resistance. So one plausible explanation is simply that a case assembled slowly until it reached a threshold. Another plausible explanation is that cultural attention created urgency. In an environment where institutions fear appearing indifferent, they may move faster. That too can be ordinary. Yet, for the public, the question remains: why did the threshold not arrive earlier? If there was evidence in 2006 and 2007, why did it take until 2019 for a federal indictment? One answer might be that the evidence changed. Another might be that the willingness to pursue changed. A third might be that legal pathways changed. And a fourth, less comforting answer might be that the system is inconsistent and depends on the people inside it. Why did the federal case arrive when it did? There are several possible explanations that can coexist. Reporting can push institutions. New witnesses can come forward. New prosecutors can reassess old decisions. Political and cultural climates can change. In the late 2010s, the public conversation about sexual abuse and power had intensified. That may have created momentum, but momentum still needs a vehicle. A federal indictment is built by investigators and prosecutors, assembling evidence that they believe can be proven beyond a reasonable doubt. So another question is, what evidence, specifically, formed the backbone of the 2019 case? And what evidence remained outside it? When Epstein was arrested, attention quickly turned to his bail status and detention. He was held at the Metropolitan Correctional Center in Manhattan, a federal jail. Detention itself becomes a story when the defendant is famous, wealthy, and facing serious allegations. In some cases, detention is routine. In others, it is extraordinary. Epstein sought bail. Prosecutors opposed. A judge made decisions about conditions. The details of those bail proceedings matter because they reveal how the court assessed risk. Risk of flight, risk of obstruction, risk to the community. The unanswered questions here are not sensational. They are procedural. What information did the court have? What did the defense propose? What did the prosecution argue? How did the judge weigh it? Then, inside the MCC, another critical event occurred. In July 2019, Epstein was found injured in his cell. Accounts differed. Some reports initially suggested a possible suicide attempt. Later, there were discussions of an altercation with a cellmate. The archive around this incident is not fully transparent to the public, but it matters because it is a warning shot. A person in custody is injured. The facility is alerted. Policies about monitoring and housing become relevant. If a facility experiences a high-profile incident, the expectation is that precautions increase. So a major unanswered question is, what changes were made after July, and were they maintained? Suicide watch protocols, psychological assessments, housing decisions, staffing assignments, frequency of checks. In custody, the practical reality is that policies can be perfect on paper and imperfect in practice. Facilities can be understaffed. Officers can be exhausted. Units can be chaotic. Those conditions do not excuse failures, but they can explain how failures occur. The deeper question becomes, was what happened in August 2019 the result of ordinary institutional breakdown or something more? We cannot answer that definitively here, but we can map the questions. In early August 2019, Epstein was in a special housing unit. On August 10th, 2019, he was found unresponsive in his cell. He was later pronounced dead. The official conclusion was suicide by hanging, yet public skepticism surged. Part of that skepticism arises from the emotional logic of the story. A person with potential information about powerful others dies before trial. That is a narrative that invites suspicion. But emotional logic is not evidence. Evidence is logs of checks, video footage, forensic findings, autopsy details, statements from staff, cell assignment records, maintenance records of cameras. After Epstein's death, reports emerged about malfunctioning cameras, staffing shortages, and failures to perform required checks. There were later charges against corrections officers related to falsifying records. There were investigations by the Department of Justice. There were disputes among forensic experts about injuries and what they implied. All of these elements feed the unanswered questions. If the system failed, how did it fail so comprehensively in such a high-profile case? If there was foul play, what is the chain of events that would make that possible inside a secure unit? What access would be required? What coordination? What time window? What would be left behind? It is possible for a suicide to occur even under monitoring. It is also possible for institutions to cover their own negligence. It is possible for rumors to spread faster than facts. And it is possible for people to interpret ambiguous evidence according to their prior beliefs. So the careful approach is to take each claim and ask, what is the source? What is the documentation? Is it consistent? Can it be verified? This chapter is a return of the case, but it is also a return of uncertainty. The federal prosecution that seemed poised to test evidence in a courtroom ended abruptly. The accused died. The case shifted. Attention turned to associates. Civil suits continued. Document releases continued. And the public was left with a feeling that the story had been cut off mid-sentence. A sentence that might have named more names. A sentence that might have revealed more structure. Or a sentence that might have ended with a narrower truth than people imagined. We do not know. And that not knowing is one of the unanswered questions that keeps people awake. But tonight, we will let it do the opposite. We will hold it gently as something unresolved and move closer to the details that might one day resolve it. Chapter 5. The Night Inside the Cell. This chapter is about a place that most of us will never see. And it is also about the limits of reconstruction. We may never know the full truth of every minute in a locked corridor. We may never know what a camera would have shown if it had worked. We may never know what an exhausted officer noticed or failed to notice in a glance through a window, a federal jail cell, a door with a narrow window, a corridor that echoes, a camera that may or may not record what it is supposed to record, because the most persistent, unanswered questions are concentrated into a small slice of time. The hours before Epstein was found dead. When you study events inside a secure facility, you are studying systems. A person does not exist alone. There are officers, there are supervisors, there are shift changes, there are count procedures, there are logbooks, there are other detainees, there are maintenance issues, there are policies about linens and fixtures. And when something goes wrong, you can often reconstruct it as a chain. A staffing shortage leads to missed rounds. A camera malfunction leads to a blind spot. A cell assignment change leads to someone being alone. A supervisor fails to check logs. A chain can be tragic without being conspiratorial. In custody, prevention is often described in terms of layers. Layer, assessment. A clinician evaluates risk, mood, statements, history. Layer, environment. Cells are designed to reduce obvious anchor points, though older facilities can have features that remain. Layer, staffing. Checks happen on schedule, and checks are documented. Layer, response. If a person appears in crisis, protocols activate quickly. When any one layer weakens, the remaining layers matter more. So an investigator would ask very plain questions. What was the risk assessment in the days before? What did mental health staff record? Were there any statements of despair? Was there any change in behavior? Then, the physical environment. What fixtures were in the cell? What bedding was provided? What clothing? What was the exact point of suspension described? Old buildings can create strange vulnerabilities. A bunk frame, a vent, a door hinge, a shelf. If a facility knows a cell has vulnerabilities, it may try to compensate with more frequent checks, which returns us to documentation. A log is not a ritual. It is supposed to be a mirror of reality. When logs are falsified, the mirror shatters. You can still reconstruct reality by using other mirrors, camera timestamps, radio traffic, keycard entries, other officers' recollections, medical response times. So the unanswered question about checks is not only whether a specific officer looked in, it is whether the system had any independent way to confirm that looking occurred. If the only proof is a handwritten mark on a page, then the system is built on trust. And when trust fails, nothing catches the fall. But a chain can also be engineered. The difference lies in evidence. One unanswered question involves the issue of surveillance footage. Reports indicated that cameras had problems and that some footage was unavailable or unusable. In a modern detention facility, a camera failure is not impossible. But the unanswered question is not simply whether a camera failed. It is which cameras, which time frames, what maintenance records show, whether failures were documented before the incident, whether redundancies existed, whether any footage was preserved, who had access, who made decisions about retention. If you wanted to settle this question, you would want a clear technical report, not a vague statement. A report that lists camera IDs, locations, storage systems, and exact periods of outage. And you would want independent verification. Another unanswered question involves the logbooks and the rounds. In custody, officers are expected to conduct checks. The frequency can vary by housing status and risk assessment. But in a special housing unit, monitoring is often emphasized. Reports suggested that required checks were not performed and that logs were falsified. If that is true, it provides a mundane explanation for the tragedy. Negligence compounded by paperwork that attempted to hide negligence. Mundane explanations often feel unsatisfying because they are not dramatic, but they are common, and they can be deadly. The question becomes, how widespread were those practices? Was this an isolated failure or a pattern? What was the staffing level? What were the training conditions? Were supervisors reviewing logs? A facility under strain can become a place where policy is performative and reality is improvisation. If you have ever been in an overworked environment, you can imagine it. Someone cuts corners. Someone signs what they did not do. Someone looks away because everyone is exhausted. And then, on a night when it matters most, the corner cutting becomes the story. Another unanswered question is the cellmate issue. Reports indicated that Epstein had been housed with another detainee at times, and that there were changes shortly before his death, leaving him alone. Housing assignments in custody are complex. They can change for safety. They can change for discipline. They can change because of space. But in high-risk situations, being alone can increase danger. So the question becomes, who authorized housing changes? What risk assessment was applied? what documentation exists. Then there is the medical and forensic dimension. After Epstein's death, there were disputes about the meaning of certain injuries. Forensic pathology is a careful field. It deals in probabilities. Certain findings are more consistent with suicide. Certain findings can raise questions. But bodies are complex, and injuries can occur in multiple ways. So the unanswered question is, what did the autopsy show? What did independent experts say? What parts were disputed? What parts were agreed upon? To settle forensic disputes, you would want full autopsy reports, photographic documentation, chain of custody records, toxicology, scene investigation reports, a clear description of the ligature and the point of attachment. In many high-profile cases, some of this information is disclosed and some is not. When it is not, the void fills with speculation. Another question involves the broader institutional response. After a death in custody, there are investigations: internal, external, inspector general, sometimes Congress. In this case, reports and public statements indicated failures, but the public often wants the next layer. Who was held accountable? Who resigned? Who was disciplined? What reforms were made? Accountability can be narrow. 2 officers can be charged. A report can be written. A facility can promise changes. And the deeper system can remain. So the unanswered question is whether the consequences matched the magnitude of the failure. If the official conclusion is suicide, it still leaves an institutional mystery. How did a person at the center of a global scandal, in a federal facility after a prior incident, end up in conditions where suicide was possible? If the conclusion is challenged, it leaves an even larger mystery. How could an external actor enter or influence the environment? How could evidence be controlled? How could staff be bypassed? Those theories require extraordinary evidence. Extraordinary evidence would include clear video of an unauthorized entry, communications showing coordination, forensic evidence inconsistent with suicide, testimony from involved parties. Without that, theories remain theories. And yet, even without theories, there is the plain fact of failure. A person died. A system did not prevent it. And the system's explanations have not satisfied many people. Part of dissatisfaction may be emotional, but part may be rooted in the record: a camera gap, a missed check, a falsified log, a facility known for problems. These are not small. They are the kind of details that turn an event into an open file in the public mind. Tonight, we sit with that open file. We do not slam it shut. We let it remain open, with labeled tabs: cameras, logs, housing, staffing, forensics, oversight. Each tab is a question. Each question has a list of evidence that would clarify it, and each list points to the same quiet conclusion. Until the archive is fuller, certainty will be borrowed. Borrowed from suspicion, borrowed from trust, borrowed from the mood of the moment, but not earned. Now, in the final chapter, we step back from the cell and look at what remains after. Chapter 6. What remains unanswered. After a death like this, the story does not end. It disperses. It moves into civil courts. It moves into document dumps. It moves into memoirs and interviews. It moves into the lives of survivors. And it moves into the cultural imagination, where it can become a symbol of impunity, a symbol of conspiracy, a symbol of wealth protecting itself. But symbols are not the same as answers. And here is the most contemplative frame we can offer, one that sits quietly under every page of this file. We may never know. not because truth does not exist, but because truth can be buried in sealed records, lost devices, faded memories, and decisions that were never written down. We may never know the full shape of certain relationships. We may never know the complete map of who suspected what and when. We may never know every step in the chain that led to the final night in custody. So tonight, in our final chapter, we return to the discipline of questions, what remains unanswered in a way that could still be answered, and what remains unanswered, perhaps forever. Let us name several categories. Before we name them, notice something quiet. In many public debates, people demand the list as if one page could settle a decade. But complex cases rarely resolve with one reveal. They resolve with many small confirmations that align. A date on a receipt matches a date on a flight. A flight matches a text message. A message matches a staff schedule. A schedule matches a visitor log. This is slow work. It is also the kind of work that makes truth feel less like a headline and more like a floor you can stand on. So here is another unanswered question, more procedural than dramatic. How much of the relevant archive is in public custody and how much is private? Some records are held by federal agencies, state and local agencies, courts, jails, hospitals, private firms, airlines and charter companies, banks, telecommunications providers. Each holder has different rules. Some records can be requested, some can be sealed, some can be destroyed after retention periods, some can be kept indefinitely. So when people ask, why do we still not know? One answer is that the archive is distributed, and distribution creates friction. It creates FOIA processes, redactions, appeals. It creates litigation. It creates delays. Another unanswered question is how much relevant material has been permanently lost. In any long-running case, loss can be accidental. A hard drive fails. A server is upgraded. A tape is overwritten. A phone is replaced. Loss can also be strategic. A device is destroyed. A record is shredded. A backup is deleted. To know which kind of loss occurred, you would need audits, retention policies, logs of deletions, chain of custody documentation. This leads to a question that is uncomfortable but necessary. When institutions fail, do they preserve evidence of their failure? Sometimes they do, sometimes they do not. If you are trying to understand the lasting uncertainty around Epstein, the answer may be that the case intersects with several kinds of institution at once, and each has its own incentives. A police department may want to show it tried. A prosecutor's office may want to defend a past decision. A jail may want to avoid liability. A private organization may want to protect reputation. In that landscape, transparency is not automatic. It has to be demanded. Sometimes it arrives through courts. Sometimes it arrives through journalism. Sometimes it arrives because a survivor insists. And sometimes it never arrives because the law permits secrecy. Now, with that in mind, we can name categories in a way that is practical. First, the financial category. How did Epstein's wealth truly function over time? What were the legitimate sources? What were the clients? What were the structures? What were the tax strategies? What were the offshore entities? To answer these, you would need financial records and cooperation, banking documents, client agreements, accounting statements, tax filings, testimony from accountants and attorneys. Some of this may exist in sealed proceedings or in private archives. Some may be protected by privilege. Some may have been destroyed. Second, the recruitment and logistics category. How were young women identified? Who contacted them? What promises were made? What payments were offered? What transportation was arranged? Who coordinated schedules? This is the category where the experiences of survivors are central, but it is also the category where corroboration can be difficult years later, because recruitment can be informal. A friend of a friend, a ride, a cash payment, a phone number. To answer these, you would want a combination of testimony and hard records, phone metadata, travel receipts, employment records of staff, payroll, vehicle logs, flight manifests cross-checked against other sources. Third, the associational category. Who visited properties? Who traveled with Epstein? Who attended dinners? Who was introduced to whom? Again, proximity is not guilt, but proximity can be a lead. To clarify, you would want timelines, not vague recollections, exact dates, evidence of presence, communications. And you would want to compare those timelines to known allegations. Who was where, when? Fourth, the institutional category. Why did the Florida case conclude as it did? Who made key decisions? What legal reasoning was applied? What political dynamics existed? Here, records can exist. Emails, memos, meeting notes. Some have been reported. Some may remain unsealed. Answering these questions requires transparency and a willingness to accept institutional discomfort. Because sometimes the story is not a single villain. Sometimes it is a chain of cautious decisions, each one defensible in isolation, disastrous in combination. Fifth, the custody category. The night inside the cell. This category is both narrow and enormous. Narrow in time, enormous in consequence. To move closer to answers, you would need full documentation. Video audit reports, maintenance logs, officer schedules, training records, incident reports, forensic materials. You would also need to trust that what you are seeing is complete. Trust is hard when documents are missing. Finally, there is the cultural category. Why this story grips the public so intensely. Part of the answer is the scale of alleged harm. Part is the involvement of wealth and status. Part is the sense that ordinary rules did not apply. And part is the ending. A death that closed a criminal case. A sudden silence where a trial might have spoken. In that silence, people build narratives. Tonight, we do not build a dramatic narrative. We build a quiet one, a narrative of archival humility. We acknowledge what is known. We mark what is uncertain. We describe what evidence would be required. And we remember that behind every document are human beings. Survivors who carry memories. Families who carry grief. Staff who may carry shame, investigators who may carry frustration. The unanswered questions are not a puzzle for entertainment. They are a measure of whether institutions can face what is difficult, whether wealth can be treated the same as poverty in a courtroom, whether victims can be heard before years pass, whether records can be preserved, whether accountability can be more than a press release. And as we end, we can allow one final possibility, that some answers will come, slowly, not all at once, through unsealed files, through careful journalism, through civil discovery, through new witnesses, and that some answers may never come, because time erases, because power obscures, because human systems are imperfect. In that case, what remains is not certainty, but a kind of vigilance, a commitment to asking the questions anyway, a commitment to documenting, and we can be more specific about what documentation would still matter. If your goal were to reduce the biggest uncertainties, you you would build a small list of high-yield questions and then identify the best possible sources for each. For the early wealth question, audited financial statements, tax filings, bank records, and testimony from accountants who handled the work. For the network question, full travel records cross-checked across systems, not just one set of logs. Corroborated communications and interviews with staff whose job was logistics. For the Florida plea question, full disclosure of negotiation communications, internal memos, and a clear legal explanation of the reasoning paired with a record of victim communication. For the custody question, a complete technical accounting of surveillance systems, including failures, complete staffing and shift rosters, keycard logs, and a transparent chain of custody for forensic materials. For the broader accountability question, what recommendations were made, which were implemented, and whether implementation was audited later. Notice that none of this requires fantasy. It requires paperwork. The difficulty is not imagining what evidence would help. The difficulty is access. Access depends on law, on judges who order unsealing, on agencies that cooperate, on legislatures that change rules, on journalists who persist, on survivors who endure the cost of speaking. And it also depends on something more fragile, time, because every year that passes can make evidence harder to retrieve. So another unanswered question becomes a moral one. What does society owe survivors when time has already taken so much? It may owe them privacy. It may owe them protection from harassment. It may owe them resources for recovery. It may owe them an investigative seriousness that does not fade when the headlines move on. Sometimes people ask why this story keeps returning. One reason is that it is not only a story about one man. It is a story about how systems respond when exploitation is paired with wealth. It is a story about how institutions behave when they are asked to pursue a case that will create enemies. It is a story about what happens when the public sees a gap between the severity of allegations and the apparent softness of consequences. And it is a story about endings. Because in most criminal narratives, a trial provides a kind of public accounting. Witnesses speak, evidence is tested, a jury decides, a sentence follows. Here, the expected accounting did not occur. Instead, the story splintered into documents, into civil litigation, into partial releases, into arguments about what is missing. That splintering is why the unanswered questions feel endless. They are not only factual, they are structural. They ask whether a modern society can produce clarity when the relevant records are private. The relevant actors are powerful, and the relevant witnesses have been harmed. Tonight, though, we do not need to solve these questions. We only need to place them where they belong, in an archive, not as obsession, not as entertainment, but as a record of what must be asked when power moves in shadow, a commitment to refusing easy conclusions. And now, as you rest, let the questions become quieter. If a final image helps you drift, imagine an archivist in a dim room. The archivist does not rush. She removes staples carefully. She flattens folded pages. She writes dates in pencil. Some documents are clear, some are smudged, some are missing entire sections. When a page is missing, she does not invent it. She leaves a placeholder, a note that says, absent. That quiet honesty is the tone we have kept tonight. We have not declared what cannot be proven. We have not ignored what has been documented. We have simply held the file open long enough to see its structure. And that is enough for the mind to release the need for a neat ending. Because sometimes the neat ending is the most unrealistic ending. Sometimes the only honest ending is the one that admits uncertainty. We may never know, not because they do not matter, but because tonight is not for solving. Tonight is for placing the file back into the archive with care. And if, someday, more pages arrive, they can be added without rewriting what came before. A new memo, a newly unsealed email, a technical report that finally explains a camera gap, a testimony that clarifies a timeline. This is how understanding often grows in real life, not in a flash, but in increments. And until those increments come, it is reasonable to live with uncertainty, as long as uncertainty does not become indifference. Labeling it, dating it, and closing the drawer gently, so the mind can loosen, so the body can soften, and in the softness, the questions can rest on the shelf, not forgotten, simply paused, waiting for daylight and careful hands, so sleep can arrive, like a slow tide. This was a quiet archive story, where the story ends, sleep begins,